And then give me a second. It's preparing. It should be ready in a second.
Okay. Okay. Hi, everyone. Thank you all for being here on this Tuesday, June the 2nd. Today, we are hosting a presentation on COVID-19. How do I avoid probates? My name is Ashley, Client Services Coordinator, and I have the privilege of introducing our presenters, Vincent Russo and Frank Bequicchio. Vincent is the managing partner of Russo Law Group. He is also co-founder of the Teresa Alessandra Russo Foundation for Children with Special Needs, which was established in the memory of his daughter, Teresa. Vincent is also a founding member, fellow, and 5th president of the National Academy of Elder Law Attorneys. Sorry about that. Joining him is Frank Bequicchio, a partner with Russo Law Group and over 25 years of planning experience. He's the lead planner in 2 of our office locations, including Islandia and Bay Shore. Frank is also a certified elder law attorney by the National Elder Law Foundation, and among many other board memberships is member of the invitation-only NALA Council of Advanced Practitioners. Now, before I pass it over, I have 2 housekeeping announcements. During the webinar, please send us your questions and we will do our best to answer everyone. But if for some reason we cannot, we will follow up after the program. Also, when we conclude the session and in today's webinar, a separate browser window should open and prompt you to take part in a short survey. We do value your opinion, so please let us know how we did, and we thank you in advance for your participation. All right, and with that, I will hand it over to Vincent to talk about today's agenda.
Okay, it's great to be with you all and with my partner, Frank. We're going to talk about avoiding probate. So here are the questions. Why should I avoid probate? What are the benefits of a revocable living trust? And how does the revocable living trust work? So the first question is really the key question is, why should I avoid probate? So Ashley, you're going to push the slides. And I'm going to stop my video here. So we're going to go back and forth, Frank and I, on today's presentation. So before we get to how do I avoid probate, we first need to understand what is probate. Frank, what is probate?
So hello and good afternoon, and thank you, Vincent, for having me on this presentation with you. So probate is a court process that's really a 2-step process. The first part of probate basically is proving that the will is valid, and then once that proceeding is done and the judge is satisfied that the will was executed properly, then the next step of probate is the administration of the estate.
So Frank, you're saying that a will is not valid until it's probated, right?
Correct. Yeah. A lot of people, just because the lawyer did the will, it's an automatic, but it still has to go through that process.
Okay. And also the court will appoint the executor. So
Correct.
Even though you've named the executor in the will, they're not able to act until the will has been probated.
That's correct.
So most people will, in their estate plan, have a will, and they'll lay out how they want to leave their assets and to whom, and in what way. And so then that probate process comes into play. Here in New York, it's the surrogates court. So Frank, why would it be helpful to avoid probate?
Well, I guess there are probably a number of reasons. One of which I think a lot of people are concerned about, is the potential delay. As we said, it's a court proceeding, so there's a process. There are documents that have to be presented to the court. Then the court has to review the documents. Depending on the estate and the probate, there may be a hearing necessary, more time. And what happens with time and courts? Money. So there are costs involved There are potential delays. There might be additional court set fees for a bond, for example, for the executor and or a trustee. So number of reasons why people would want to avoid probate.
And now during this COVID-19 emergency period, we really see how timing can be so important. It is very difficult right now to file a will in the probate court, the surrogates court here in New York, and have it processed and approved. So it could be months before someone is actually appointed. And so if families need the access to assets or the income, then having lost the opportunity for months really can be very harmful. Also, the stock market has been going up and down like a yo-yo. And so during this period where a will is being probated, no one has the right to make management decisions as to the assets.
Right.
Now, Frank, if we have a probate proceeding and someone wants to challenge the validity of it, let's say a unhappy child who was disinherited, what would you say about that?
Yeah, and that's another reason, we talk about indicators in terms of why somebody would consider avoiding probate. And that's a big one when you're afraid or think that someone might challenge your estate plan. And there are certain people who have the right to do that, whether you like it or not. But certainly you can make it more difficult on them. And we'll talk about that in a little bit. But it's very easy for somebody who wants to challenge your will, for example, through the probate process, to make things difficult and more complicated and take more time. And again, going back to time is money. So it's very simple for somebody to make your potential executor's life difficult, and the other people who might be involved with the probate, with very little effort, they can make it more complicated and much more costly.
Yeah, and in a will challenge, it could be tens of thousands of dollars in legal fees. It can get really ugly too among family members. Next slide. So let's talk about the different ways one can avoid probate, and there are basically 3 ways, Frank.
Yeah, so, and you see them there on the screen. So I'm going to save the best for last. So we'll talk about the other 2. So beneficiary designation. So classic example there would be life insurance. You have a life insurance policy. You should have at least one person named as a beneficiary in the policy. And assuming, of course, that that person survives you, the money goes to that person, regardless of probate, regardless of will proceeding. Same with joint owners with right of survivorship. A jointly owned bank account, for example, or jointly owned stock that has that designation of right of survivorship. If it's 2 people, for example, and one person passes away, the other person automatically owns the account and the money that's in the account. No need for probate. But you can't do that with everything, and sometimes those are not the best scenarios. So a revocable living trust, if somebody's looking to avoid probate, is very often going to be the best option.
Yeah, the situation, we see it a lot, Frank, where families say, let's leave, I want to leave my assets to my 3 children equally. But then maybe they have a bank account with joint or right of survivorship going to only one child. Well, it wasn't intended that that child would actually keep 100% of that joint account. Or perhaps it's a life insurance policy. We actually had a case once where the client had a life insurance policy for $10,000. Frank, you want to guess what it was for?
I'm going to guess that the parent probably assumed that it was going to be used for funeral money.
That's right, and named the oldest child. And when the child received those benefits, the child took a position that mom loved me best and kept the $10,000, even though it was clear that that was the intention of the life insurance policy. So, so that can be a little problematic. And so the Revocable Living Trust really allows you to keep everything in a way that you're able to make sure that your children inherit equally.
And you're right, Vincent. And other examples too. If you have somebody in the family who might have special needs, for example, those needs can be addressed through a revocable living trust, so that that person can be protected. Any benefits they might be entitled to that can also be protected. Oftentimes we see that, parents especially, they'll go one of two ways. Not knowing any better, they'll name that child as a beneficiary, for example, on life insurance, and then that becomes a problem when they inherit that money. Or they'll do the opposite and they'll say, well, I know enough to know that my adult child, for example, who's getting SSI and Medicaid can't have any money, so I'll leave them out completely, and I'll name my other two children as beneficiaries, and they'll do the right thing. And that could be just as much problem.
Right. Good. Really good points. So let's get into revocable living trusts. And my question for Frank is, how does it work?
Well, the beauty of a revocable living trust is that it's you. When you set up a revocable living trust, you are the settlor, that's the person who sets up the trust, and you are almost always the trustee. So you're in 100% control when you have a revocable living trust. I'm saying revocable, revocable, tomato, tomato, interchangeable. So a revocable living trust is you. I often, when I explain it to clients, it's just you wearing a different hat. Everything that's in the revocable living trust is yours. You have the right to take money out, put money in, move it around, income, principal. You're controlling the whole show. From a tax standpoint, it's your trust, it's your money, therefore it's still reportable by you on your personal income tax returns.
So Frank, if you have a revocable living trust and you set it up and you're the trustee, can you revoke or amend the trust at any time?
Yes, you're 100% control. So you can change it anytime, which would be an amendment. You can revoke it completely if you decide for some reason, or if something changes in your for example, with your health, if you need to revoke it and do something else. All of that is on the table when you have a revocable living trust.
Okay, so it's really a mechanism. So when you have a revocable living trust and you pass away, does the trust have to be probated?
No, and that's one of the beauties. It's, I hate to say it as a bump in the road, but so when you pass away, the trust will now act like a will. It's not a will, but it will act like a will. So the main difference between the two is that the revocable living trust says, while I'm alive, here's what happens to the money. It's mine. I can do with it whatever I want with it. When I pass away, here's what's going to happen. It's going to go to my 3 children, for example, that you gave before. So in the revocable living trust, you would name a successor trustee. So for example, if I was setting up my own trust and name myself as the trustee, I would put a provision that says when I passed away, my oldest son, for example, would become the successor trustee. When I pass, he becomes the trustee. That's it. There's no need to go to court. There's no need to wait for a judge to review the document to appoint anybody. It's instant.
All right, so you've mentioned how the trustee steps in. So when that trustee steps in, what responsibilities do they have?
Well, personal, frankly. And the trustee's responsibility basically is to do what the trust says. So if there are any last expenses, there could be funeral expenses, there could be maybe credit card bills or other bills that have to be paid from the person who passed away. And then the trustee's job is to manage what's in the trust for the time that it's in the trust, and then distribute it in accordance with the terms of the trust.
So it sounds like the successor trustee in a revocable living trust is like an executor of a will.
Same concept, yeah.
And so does the estate, the trust in this situation, does the trust have to file any tax returns?
So yes, when the person passes away, the trust becomes irrevocable at that point, because the person who had the power to revoke it or change it has now passed. So the trust becomes irrevocable. It becomes its own entity. So while the settlor was alive, the Social Security number was used for tax purposes. When the settlor passes away, the trust now is irrevocable. The trust has to get its own tax ID number. Well, the trustee would get it, of course, from the IRS. And from that point forward, it becomes a new taxing entity, and any income that's earned during that time before the assets are distributed is reportable by the trust.
Now, I have another question for you. The assets in the trust, let's say someone had more significant wealth and they had $5 million of assets in this trust. You know, they did well. Will that be part of their estate for estate tax purposes?
Absolutely, correct. So the person who set up the trust, this revocable trust, because all of the assets in there are still theirs, everything in that trust is taxable to that person's estate.
Okay, and let's say I'm a beneficiary of the trust. I'm one of, well, actually, I'm one of 8 kids. So let's say the 8 of us were beneficiaries of a trust. Do I have any rights to, like, an accounting? Like, how do I know that when I receive the distribution, it's the right amount?
Yes, that's correct. So yes, the beneficiaries of a trust do have the right to request an accounting from the trustee. So of course, that's, you know, a bit of a check and balance. We want to make sure that the trustee is doing the right thing by the terms of the trust in terms of managing and distributing. Very often we will put this in the trust document itself that says that the trustee is responsible and accountable to the beneficiaries.
Okay, and just one more question about just how this all works. When someone passes away and that trustee steps in, and you mentioned they don't have to go to court, they can do it outside of a court proceeding. I assume that really speeds up the whole process, so then the beneficiaries, have access more quickly to the assets.
Absolutely, absolutely. Yeah. And again, one of the benefits to having the revocable trust is avoiding that probate process.
Okay. And one of the really big questions that we're asked all the time when clients are interested in a revocable living trust is they ask the question, well, who should be my successor trustee? Should it just be my closest living family members, or should I be thinking about other choices? And because you mentioned these duties of a trustee, and they seem very important. Personal liability, there are things they need to know and do. It's going to take time. So Frank, can you talk about the choices when selecting a successor trustee?
Yeah, sure. And I think there's not a whole lot of decisions that are more important than this one. It's easy to set up a trust and say, okay, I'll be the trustee. I'm familiar with everything and I'll do what I have to do. But then if something happens to you, who's the right person then to step in and handle things? So part of our job, I think, as planners is to discuss with clients the different options, and you see them here. So probably more often than not, I would say overwhelmingly, it's going to be another family member, a trusted family member. Again, this is a job. Being a trustee is a job, and you want somebody who not only would have at least some wherewithal to be able to handle whatever your affairs are, because what we want to look at is, what is the trust going to hold? Is it going to hold just a piece of property, or is it going to hold a piece of property, maybe a rental property, have some investment assets, have some bank accounts? So you want somebody who's going to be able to at least be able to manage on some level those things, and I think more importantly, to know where to go to get the right help. We often talk here about a team approach. We, as the attorneys, will work with the client's financial advisor. We'll also work with the client's accountant when need be. So I think picking a successor trustee is somebody who knows to do all of those things if they don't know how to do things themselves. They also need to have the time to do this. I mean, depending on the type of trust and what needs to be involved in the administration, it can be time consuming. So you want to have the right person. That's part of the discussion. Professional advisor is another option in terms of having a trustee. I've got a few clients they've had advisors for years. In fact, I'm working with a client right now who came very close to picking his financial advisor as his executor and his trustee over his children, because he trusts his advisor that much. And then we have the attorney. So we at Russo Law Group, we will offer that as a service more often than not when there really is no other option. I mean, we're happy to step in, but when there's no one else, some people just don't have either the right person, or they have a very small or limited family dynamic, and they don't really have anybody else to appoint. We're happy to offer that service and do a good job for them. then of course there are trust companies, there are banks that actually have departments that act as trustees. You know, it's an option. You know, in the right situation, I think it's good. You know, more often than not, I think you're better off trying to find somebody. You know, with the trust company like this, you kind of lose, to me, the personal touch in case there needs to be some interaction between the trustee and the beneficiaries.
Very good. So basically you've outlined 4 different options. I'll just supplement with a couple comments. With the trust company or bank, if the assets are under a certain level, they may not even be interested in being a trustee. So typically they're looking for more significant assets in a trust before they're willing to step in. With the professional advisors, if you're thinking about a financial advisor, often the financial advisor cannot act as a trustee if they're also going to manage the assets due to ethical rules. So that may take a choice off the table. I know CPAs have been willing to step in the appropriate situations as well to be considered. So typically clients will look at family or friends first, but where I say one of the places where we've been brought in has been when the family they don't get along. They could be dysfunctional. And do you really want to put one family member in a trustee position and now the others have to deal with that trustee, and emotions can get high, things can go awry. So that, having an outsider sometimes can work out very well. Also, we've stepped in as trustee with special needs trusts because of our experience and knowledge with spending time with families, with children with special needs, and understanding how they need to be taken care of, the services that they may require, and government benefits that could be involved. And so we are trustee in a number of those situations. So let's go on and talk about now kind of summing up when the revocable trust makes the most sense. Here, what are the, Frank, typical situations where you would say, oh, if you have this situation, you really should think about doing a revocable living trust?
Yep. So I think the number one is the quick access we talked about before. There's no delay like there is with the probate process and the court proceeding. If you want there to be the family to have quick access to your funds for whatever reason, a revocable living trust is the way to go.
Yeah, Frank, I can jump in, because we're living in this COVID-19 times where, unfortunately, so many people have passed away, and with the courts closed or just open for emergency measures, and delays could be months, if not even a year or more. We're kind of understanding that sometimes bad things can happen to good people, right? And having a plan that ensures quick access to assets really could be very important.
Yeah, I think you're right. I mean, it's a process before the COVID pandemic, and this has just exacerbated the issue with right. Delays. Yeah. And kind of leads to the next point, which is saving on legal fees and costs that are associated with probate. When there's no probate process and no need to go to court, you're probably going to still have some legal involvement, but it's going to be diminished by avoiding probate. The other two, I think, are probably more common. One is if you've got property in multiple states. So if you own a piece of property here in New York, let's say on Long Island, for example, and you've got another place probably down south where it's warmer, Florida or maybe the Carolinas or maybe Arizona. If you pass away as a resident, for example, of New York, and you've got a piece of property in another state in your name, there's actually probate in both states because the New York courts don't have any jurisdiction or power over your Florida condo, for example. So you'd have probate in New York, hire an attorney, go through that process. Then you'd have to hire an attorney in another state to go through that process. Again, two separate processes, more costs. A revocable living trust can avoid that. And then last, we talked about, again, just the challenge, somebody wanting to contest your plan. A revocable living trust does not stop the ability from somebody from contesting your plan. It just gives them, it makes it harder for them because there's no court proceeding.
Okay. So what do you do now after listening to our presentation today? Before I get into what I'll call 3 steps to success, I just also want to mention that often we'll do a simple, what's called pour over will attached with the revocable trust plan. So Frank, why would we do that?
So I call that the safety net. So if your plan is to avoid probate, then ideally everything that you have should fall into one of those 3 categories we talked about up front. So if you're setting up the revocable living trust as the hub of your plan, then your property, your real estate, for example, your investment accounts, non-retirement, would be transferred or retitled into the name of your trust. You may have retirement accounts that have beneficiaries named, but there may be an account, and there often is, unfortunately, we find out after the fact, there's an account that somebody forgot about, or there's something that comes along later, or you open up a new account and you forget to put it in your trust. So what the will says then is basically, as Vincent said, is that when I pass away, if there's something not in my trust, put it in my trust.
Right. So then everything flows from the trust out to the family. So it's, as you said, it's like a safety net.
Yeah.
So the 3 steps here would be everyone should have a plan. And if you have no estate plan in place, that actually is a plan. It's a plan of disaster, quite frankly. And so we say you start with, you have to have a plan. And if you're building a house, you have to have a foundation to the house. And we think the foundation is a will or a revocable living trust, a durable power of attorney, healthcare proxy, and a living will. Those are the 4 essential documents. So you need to think about what plan do you want to put in place, or if you don't have a plan, you may want to meet with a professional to figure out, well, what should be my plan? From there, the elder law attorney, the special needs attorney, the estate planner with experience can say, okay, here are the steps you should take, here are the fees involved, and then the next action step is go ahead, retain that professional, and get your plan implemented as soon as reasonably possible. Because as we know with the COVID-19 virus, you just don't know what's going to happen from one day to the next. So that would be really a good step to take. Action is key. Next slide. So that brings us to questions and answers. So Frank and I will show our video screen here. And thank you, Frank, for your presentation. And I see we have a handful of questions. So question here, my co-op will not, this is from Corinne, who's a good client of ours. She has a series of questions. My co-op will not permit me to put it into my RLT. Can someone challenge the probated part of my estate? How can I avoid that? So that's a real challenge. I think I'll jump in on that one, if I may, Frank, which is if the co-op will not let you place it into a revocable living trust, the only other solution to avoiding the co-op coming under your will would be if the co-op will allow you to own it joint with whomever you want to be the beneficiary. Now, if you want it to be split up among 20 beneficiaries, that's not really going to work as a practical matter. So that would be really the only way of avoiding the co-op coming under a will. Frank, unless you have some other thought.
The only other thought I have is, and we'd have to get the co-op's permission, is to do something like a life estate agreement, if the co-op would honor that. So it would be that the person who owns the co-op would sign an agreement with whoever, as you said, the beneficiary might be, that in essence would allow the owner to stay in the co-op for the rest of his or her life, and then upon passing, it passes to the beneficiary under the agreement. But that would mean the co-op acknowledging and accepting the agreement. So
Right, and also, they may have restrictions because the beneficiary may not live there, and so that creates other issues, or may not be financially stable. Another question has to do with minors who inherit under a revocable living trust. Do they have to have guardians appointed to protect their interests? So here, Frank mentioned right up front when I asked him, well, what are the duties of a trustee? He said, well, what did the document say? What provisions are in that document? So here it's the same situation. If it's held in a trust for the minor, then you don't need a guardian, a legal guardian. But if it was going outright to the minor, you're going to need a legal guardian, which is going to move you back into surrogate's court to deal with that. Frank, if the beneficiaries want an accounting from the trustees, who pays for it? And does the money come from the trust to cover the cost?
yes, so that's a cost of doing business. That's the cost of the trust administration. So that's going to come off of the top.
All right. And the last question has to do with fees. Trustees, do they get paid? And what suggestions do you have as to so that they can get paid for managing the trust over time?
Well, I'm glad this question was asked, actually, because I realized before that I wanted to mention about trustee commissions when we were talking about the trustees and their responsibilities. So trustees, New York State has a statute that has a calculation for how a trustee gets paid. It's based upon the value of the trust. You can also override that into the document and put what the fee is to be. Of course, the trustee would have to agree. So short answer is yes, trustees can get paid. Very often when it's family members, they don't get paid unless it's maybe going to be an ongoing administration. But if it's going to be something where, similar to a probate, where the trustee is going to collect the assets, distribute them according to the terms of the trust, more often than not, they're not going to take the commission because the trustee commission is taxable as income to the trustees.
Right. So if someone steps in as a trustee and then it's going to be over time, the way the commission works in New York is it's in two parts. There's an annual commission that's paid each year for doing the job of managing the assets and income on an annual basis. And then there's a fee for collecting the assets at the beginning and then paying them out to the beneficiaries, and that typically gets paid at the end. All right, let's go to the next slide. So we just want to take a moment here because as a consumer, one of the real challenges is how do you decide on which attorney or law firm to use? And I can understand that can be a difficult challenge at times to understand how do you make that decision. So we want to just take 2 minutes and talk about what we believe makes our law firm, Russo Law Group, different from other firms. Frank?
So I think kind of a blanket statement here is I would say that we've got you covered in a number of ways. So we have a number of office locations throughout Long Island, and you know, Long Island is so long and thin, Suffolk County in particular. We more often than not have a location, a convenient location that's going to be within a reasonable distance for you. We're very strong and have a lot of experience in handling crisis situations. You know, unfortunately, we're seeing a lot of that now with what's going on with the pandemic, with people dying and you know, also becoming ill and needing care. And I think one of the things that I feel in terms of our firm is that the people here are compassionate, passionate, and experienced. So I think we're really good in a number of different ways in handling crisis situations, being, you know, personal with people and getting them through it and helping them out. We've got multiple licenses. So aside from New York, we're able to help out with people in Florida, for example. But aside from that, we have a network of other attorneys. You know, Vincent has been in the game for a while and is nationally recognized himself. And he's developed this network of attorneys that are all very experienced. And, you know, I always feel like when somebody comes to us and they need somebody, for example, in Arizona, we can give them somebody that we're just, you know, looking it up in a book. We know the person more often than not. We have a relationship with them, and they have kind of the same core values and experience that we do. So we can recommend you to those people, to those attorneys as well. We do a lot with community involvement. Ashley, I think up front mentioned the Teresa Foundation, which Vincent has through his family for his daughter Teresa. Vincent and his family have always been involved with CP NASA for a long time. The staff is always doing community work. We work with ADRC, the Alzheimer's Disease Resource Center, with caregiver groups and being on the board and legal advisory committee, supporting the frontline workers, which is something we're kind of proud of that we've done over this last few months with the pandemic. So a lot of community involvement. And I think the other thing I want to mention is the client maintenance plan. We have we call it peace of mind. You know, so one of the things that I feel like is when somebody comes in to see me, if they don't leave feeling better, I feel like I didn't do my job, or at least didn't do it as well as I could have. Because I feel like that's our job, is to give you peace of mind. You come in with goals or concerns, and we want to help you get through those. And the maintenance program, our peace of mind program, is a way of us staying with you throughout the months, constant contact with you, and understanding what's going on, so that if something happens, we are as up to date as we can be. So I just think it's a terrific program.
Thanks so much, Frank, and for your presentation. During this crisis, we did create a COVID-19 crisis response page on our website, which we urge you to access for essential information and information about the reopening of our law firm. You can always contact us by phone, 516-683-1717, or go to our website at vjrussolaw.com. So if anyone has any further questions after the program ends, please don't hesitate to email us. And Ashley, I don't know if you have any closing words at this point.
No, sir. Just please, everyone, if you have a minute, complete the survey. That should pop up on your screen once we close the webinar.
All right, so everyone continue to be safe, be careful out there, and we wish you well. And if we can help, you know we're there for you. Have a great day.
Have a great day, everyone.
Thank you.
Thank you.